No slides, just all you. So please help me and thank you.
Thank you, Provost Wilson, for your kind introductions, and especially for the opportunity to be the Waite Chair in this academic year. I'd like also to thank Father Hendrickson, Father Kim Lennon, Rector of Jesuit Fraternity, fellow Jesuits, priests, and religious, and colleagues from university and law school, especially Cardinal Joseph Ratzinger and Dean Sarah Blood Cousins, all students and friends and colleagues from university who are here today. It's an honor for me to be able to deliver this lecture. As Provost Wilson said, that I will just use the old school, so I will just speak, and I hope that you get bear with me. So I'd like to begin my lecture today with a quotation from Cardinal Joseph Ratzinger, or rather known as Pope Benedict XVI. The quotation is taken from his address at the Academy of Moral and Political Science in Paris in 1992. In that address, Ratzinger remarked that, quote, Alexis Tocqueville's Democracy in America has always made a strong impression on me, close quote. Ratzinger explained that Tocqueville saw as an essential condition the fact a basic moral conviction was alive in 19th century America, one which, nourished by Protestant Christianity, supplied the foundation for institutions and democratic mechanisms. Ratzinger explained that democratic institutions cannot be effective and sustainable without common ethical convictions inculcated by historical foundation of a culture and ethical religious judgments. In his view, a culture and a nation that cut itself from the great ethical religious forces of its history amounts to committing suicide. So the survival of democracy from the temptations of nihilism and totalitarianism is dependent upon the cultivation of essential ethical convictions. So this statement needs some caveats. The first issue to be clarified is whether Ratzinger was downplaying Catholicism while praising Protestant values that influence American democracy. If one studies carefully democracy in America, one notices that while Tocqueville observes the rule of the Protestant Christianity in America, he pays special attention to Catholicism in America. Tocqueville argues that among the different Christian faiths in America, Catholicism appears to him to be one of the most favorable to equality conditions. In a chapter titled On the Progress of Catholicism in the United States, Tocqueville even argues that there is a hidden instinct leading Americans to Catholicism. He even makes a bold prediction that America will move in the direction of either Roman Catholicism or unbelief in Christianity altogether. So presumably, Ratzinger admired democracy in America not simply because of its influential Protestant values, but more importantly, because of the special value it placed on Catholicism. But the proposition that Catholicism has a great place in American history will undoubtedly provoke criticisms, because the United States is not a Catholic nation. But while it is true that the United States is not a Catholic country, different scholars have argued that the theory behind and responsible for the framing of the U.S. Constitution is similar to the teaching of Saint Robert Bellarmine on the state and government. Along the same vein, there's an argument that the U.S. Declaration of Independence was indebted to Jesuit Saint and Cardinal Robert Bellarmine. But some scholars have refuted these propositions. Their argument is that the U.S. Constitution is based on the Puritans' political theology instead of Catholic theology. The founders transformed the Puritans' ideal of the covenant community into a theory of public virtue, discipline, and constitutional order. Following the American Revolution, this Puritan-inspired idea grew into full-fledged state and federal institutions in the new constitutional republic. So there's no conclusive evidence that the U.S. Constitution is influenced by Catholic theology. But Joseph Ratzinger might have been onto something else when he mentioned his fondness to democracy in America. In his introduction to democracy in America, Tocqueville proposes what he called a new political science to deal with the rise of distinct kind of humanity in the age of equality. A new kind of humanity that is increasingly isolated and alone. So what was the new political science he proposes to offer? Tocqueville never explicitly elaborates this new political science. He never refers to it again after the introduction of democracy in America. Would it be possible that Tocqueville's new political science refers to the rule of Catholicism in American politics? So when Ratzinger was praising democracy in America, he was intimating Roman Catholic constitutional theory. This speculation certainly begs the question of whether there is any Roman Catholic constitutional theory in the first place. If yes, then what is Roman Catholic constitutional theory? A short answer is yes. Roman Catholic constitutional theory is a dialogue with politicians about things that belong to Caesar and things that are not Caesar's. We don't want to confuse these two things, because when God becomes Caesar, it is not a good thing. And when Caesar becomes God, it is much worse thing. Roman Catholic constitutional theory is concerned with the disorders of the soul of both the politicians and the citizens. It is concerned with the soul of politicians because they are the ones who order the deaths of Socrates and Christ. At the same time, it concerns the soul of citizens because, as Greek philosopher Plato says, the condition of the human soul will determine the type of city that they live in. For Plato, to know the people's soul, ask them in what kind of city they live. So this brief statement is the starting point of Roman Catholic constitutional theory. So in this lecture, I will use the approach employed by political philosopher Leo Strauss in his famous essay, What is Political Philosophy? In that essay, Strauss tried to explain what political philosophy by distinguishing political philosophy from political thought in general. So following Strauss' approach, I will explain Roman Catholic constitutional theory by distinguishing it from constitutional theory in general, an element of constitutional theory in particular. In the first part of our lecture, I will differentiate Roman Catholic constitutional theory from constitutional theory in general. In the second part, I will distinguish Roman Catholic constitutional theory from constitutionalisms. In the third part, I will explore its differences with political theology, and finally, I will conclude by contrasting Roman Catholic constitutional theory with theocratic constitution. So first, Roman Catholic constitutional theory must be distinguished from constitutional theory in general. Legal scholars today usually understand constitutional theory as the theory to guide the interpretation of a written constitution. Thus, constitutional theory is about the nature of a constitution and how judges should interpret and apply it. Some legal scholars understand constitutional theory as an effort to justify a set of prescriptions about how certain controversial constitutional issues should be decided. Such understanding of constitutional theory has its American bias. Over the last few decades, there have been two major competing constitutional theories that have been used to interpret and give meaning to the US Constitution: originalisms and living constitutionalisms. So from the American perspective, constitutional theories are meant to influence how judges decide complex constitutional cases or validate the outcomes and legitimacy of constitutional decisions. The American perspective on constitutional theory is centered on the judicial interpretation. But there is a different perspective on constitutional theory that is based on the character of its political association, that is, the state. To understand the differences between these two perspectives, we can start by examining the European discussion on the subject matter. For example, German legal theory focused on the law of the state, or Staatsrecht. In the late 19th century, German jurists redefined the idea of the state by arguing that the state must be understood as the union of three elements: territory, people, and ruling authority. But then they began to equate the concept of state solely with the ruling authority and to reduce concept of state to one element only, in which the state become synonymous with the governmental office. For example, German legal scholar Carl Schmitt, in his treatise on constitutional theory, argued that the state and constitution are intertwined. Schmitt explained in his treatise that a proper understanding of the term constitutions need to be limited to the state. The European or German discussion on the state and constitution showed a different approach than the American approach. But this European or German approach has its own limits. If we understand a state as a political association, we need to understand what political association is. If we agree that political association is a society, then as Leo Strauss says, we cannot define the polis or the country or the state without answering the questions of what constitutes this kind of society. Society cannot be defined without reference to its purpose. The European tradition studies and understand the purpose of the state in many different ways. Again, I'm going back to Carl Schmitt. He argued that the purpose of the state is to distinguish between friend and enemy. And the political sovereign is the person who can make the distinction between friend and enemy. The accomplishment of the state as a political unity is to relativize all the tensions and conflicts that arise within it and create the state's peaceful order. So for Schmitt, the Constitution cannot be reduced to a set of written rules, but rather a political decision taken by power or authority that exists politically. The relationship between state and society in terms of homogeneity is one of the subject of intense debate among the leading European jurists in the late 19th and 20th century. The crux of the matter is how to establish the unity of relationship between and among individual citizens who have their own will, how to guard the concept of political unity against any totalitarian temptation. Here comes Roman Catholic constitutional theory. Roman Catholic constitutional theory sees the state as not based on governing authority, but rather on human nature. Here, human nature shall be understood as a psychological meaning, but rather in its full philosophical sense. The state originates in the bodily and spiritual nature of human beings. Human beings are social and political beings. If bodily nature makes them more dependent on other beings of their own nature. As St. Thomas Aquinas says, since man by nature is a social animal, he needs assistance from other men in order to obtain his own end. Now, this is most suitably done if men love one another mutually. Hence, the law of God, which directs men to their last end, commands us to love one another. As originating in human nature, the state is part and subject to the order of the Creator. To live in a state is to live under God's order. As Aquinas states, divine providence governs man, and it belongs to divine providence to keep all things subject to it within the bounds of right order, namely so that each thing be in its place and degree. Therefore, God, through the divine law, directs human beings to love one another, so that each one remain in his own order. But the origin of the state based on human nature doesn't mean that it involves unfree compulsion, but rather free nature. The state must be based on the cooperation of the free will of human beings instead of coercion. Roman Catholic constitutional theory also differs from general constitutional theory concerning the perfection of human nature as the citizen. As the German jurists consider the purpose of the state to establish political unity, they take less attention to the fact that behind the constitutional ordering of the state, they are imperfect human beings. Either as citizens or state apparatus, they are supposed to observe, comply, or execute the constitution of the state. The social and political nature of human being reaches its perfection in citizenship in the state. But when the state is not defined for the purpose of helping the citizens to perfect their nature, the perfection of the mind and the heart of the citizen is far from reality. As I argue, Roman Catholic constitutional theory defines the state based on human nature as social political beings. One of the essential facts of human nature is capacity to communicate via language, which is attached to the mind and reason. St. Thomas Aquinas explained that speech is proper to human beings since it is proper to them in contrast with other animals, to know good and evil, just and unjust, and the like, which speech can signify. So as part of their nature as social political animals, human beings have the capacity to know good and evil, unjust and unjust, and so on. But instead of corrupt nature after the fall of our first parents, human beings cannot fulfill what he could do with his own natural powers. St. Thomas says, for human beings are the best of animals if they have the complete virtue to which nature inclines them. But human beings, if they have, should be without law and justice, are the worst of all animals. Indeed, sin has diminished humans' natural inclination to virtue after the fall. Considering the human inclination to virtue is diminished on account of original sin, that the state is necessary for creating a political order that could contribute to healing the wounded soul through the promotion of virtues. So one of the purposes of the state is to help human beings to reach perfection through acquired virtues. In his treatise on law, St. Thomas Aquinas explained that human law is framed for human beings, the majority of whom are not perfect in virtue. In different part of his works, he explained that prudence and virtue, which of themselves are ordered to the good, belong to man according to his nature. But when a man is evil, he uses his asserted arms to do evil. For example, by his shrewdness, he thinks up different frauds. The bottom line is that human beings without virtue and prudence can do and create evil. St. Thomas' emphasis on prudence provides two important insights into Roman Catholic constitutional theory. First, there are two important elements in prudence in human intellect: remembrance of the past things and understanding of the present. Both qualities that are necessary for a proper judgment in constitutional theory. Second, prudence is related to providence. Providence resides in divine intellect, but it presupposes the act that is ordered toward the act. hence it belongs to prudence to direct everything toward the end. In Roman Catholic constitutional theory, prudence is necessary because it directs constitutional directives in the order of things toward the end. As mentioned earlier, constitutional theory in the American context is often confined within the battle over a method of interpretation. The debate over originalism and the beefing constitutionalism in the last 50 years, however, has neglected the elements of the imperfection of human beings in regard to virtue and prudence. In recent years, the debate has moved to a different front of battle. The originalism was not only under assault from the left, but also from the right. For instance, Justice Neil Gorsuch's opinion in Bostock v. Creighton County has been perceived as a recipe for disaster for originalisms, as he used textualist techniques to argue that the 1964 Civil Rights Act prohibited anti-transgender discrimination in the workplace. While there are some shortcomings of originalisms, the critics have failed to see the crux of the matter is not about originalism per se, but rather the imperfection of our human nature. Judges who decide the case are human beings who often lack prudence and virtue. In The City and the Man, Leo Strauss is concerned that our judges are more influenced by social sciences than the Ten Commandments. Strauss published his treatise 60 years ago, but his concept is still relevant today. Turning again to the Bostock case, one can debate whether Justice Gorsuch really relies on social sciences in his opinion. When it comes to Ten Commandments, one can argue that he is a secular judge sitting in a secular court, so we cannot expect him to uphold the divine law. But interestingly, in his opinion in Bostock, Justice Gorsuch talked about the notion of evil. He wrote, "The Title VII application in the case reaches beyond the principle of evil legislators may have intended or expected to address." So the question is, if a secular judge like Justice Gorsuch wanted to discuss the principle of evil, which moral ground did he use? How can he ignore or reject the Ten Commandments? So now I will move to the second part of my lecture. Following the discussion of constitutional theory in general, I will discuss now the differences with the Roman Catholic constitutional theory and constitutionalism. Constitutionalism is an ambiguous term. It means different things in different settings. But in general, constitutionalism has one essential quality. It is a legal limitation on government. It is antithesis of arbitrary rules. It's opposite of despotic government. It is government of rule of law instead of government based on the will. This notion is commonly known as negative constitutionalism. But there is a notion of positive constitutionalism, which is not only preventing governmental abuse, but also establishing institutions that allow government intervention in alleviating poverty, promoting public health, protecting the environment, etc. How the Roman Catholic constitutional theory address these two subjects? I will start with negative constitutionalisms. In terms of negative constitutionalisms, there's no effective way to prevent the abuse of power without understanding again the imperfection of human nature. I will start with the Federalist Paper, which is often considered as the foundational text of modern American constitutionalisms. The Federalist Paper was originally published to explain and defend the proposed United States Constitution in 1787, which was later ratified in 1789. The central thesis of the Federalists is that the American Constitution should be a republic, not a democracy. James Madison defines a republic as a government which derives all its power directly or indirectly from the great body of the people and is administered by persons holding their offices during pleasure, for limited period, or during good behavior. Madison envisions a government that exemplifies the rule of reason, in which governmental power is exercised by the best men in the country who are qualified to govern for public office. However, Madison presumes that they are wise and virtuous candidates for public office, while Madison realizes that there are some depravities in human nature. Is pretty optimistic that a small group of virtuous citizens would govern well. Madison is confident that a good constitution would provide a reliable procedure for selecting virtuous candidates and keeping them virtuous in the office. Madison's solution for government to control is that relies on the premise that the interior structure of government, as its several constituent parts, made by the mutual relations, be the means of keeping each other in their proper places. Then Madison, Alexander Hamilton, wrote the famous passage, "If men were angels, no government would be necessary." If angels were to govern men, neither external nor internal controls of government would be necessary. In framing a government that is to be determined, to be administered by man over man, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place oblige it to control itself. In summary, the Federalist appeals to the constitutional mechanisms that enables the virtuous politicians to control themselves as the effective way to control the government. We all know that Madison's solutions is not always effective, because the individual may betray their duties while in the office. Above all, there's a problem of human imperfection. So even good politicians need help to avoid evil. Here again comes Roman Catholic constitutional law. It sees that law in general and the Constitution in particular is incapable of remedying human ills. The cause of and cure are ultimately spiritual. St. Augustine believes that in the limit of politics in remedying human ills, because politics is bound up in the pursuit of glory, which, when disordered, becomes the lust of power. He called it libido dominandi. The libido dominandi is political original sin, the manifestation of pride in politics. St. Augustine refers to scripture that calls pride the beginning of all sin. The pride is so powerfully corrosive that no mere human effort can prevent its proactive effects. Just as original sin corrupts the divine goodness in human nature, so does the libido dominandi weaken the justice in politics. And at the same time, it prevents an ordered pursuit of glory in politics. The danger of pride is inherent in politics. Pride in politics entails a lust of power, and the political realm always attracts people who love power. Because pride is the source of people's ontological disorder, a good constitutional system can never cure its cause. The lust for power can never be redeemed by human means, but only by God's divine grace. For St. Augustine, pride is the disease that requires divine healing. And the healing is humility. As Augustine says to God in his Confessions, "For you alone are the healer of the disease that affected me, you who resist the proud but give grace to the humble." In other words, humility is the path where human beings, led by God through grace, can be restored to their original nature. The grace of God allows humility to reveal counterfeits in human nature. By ripping away the prideful mask, the humble people will be able to regain their fullness of being. Following the thought of St. Augustine, we can turn to the great American statesman, George Washington, who embraced Augustinian political humility. Washington made many references to humility in his public address. For example, in his circular letter to the states on June 8, 1783, Washington urged the American leaders to do justice, to love mercy, to demean ourselves with charity, pacific temper of mind, and humility. Moreover, he asserts that without a humble imitation of whose example in these things, we can never hope to be a happy nation. So in both passages, humility is crucial, not only in the theological context, but also in the life of the patient. Now I return to positive constitutionalisms. As I explained earlier, the purpose of the state is very crucial to understand constitutional theory. The understanding of the purpose of the state defines the notion of positive constitutionalisms. Take, for example, the rise of common good constitutionalism promoted by Harper Professor Adrian Vermeil, who argues that the purpose of the state is to promote peace, justice, and abundance, which include health, safety, and economic security. While the people's welfare is important, Roman Catholic constitutional theory believes that the outstanding feature of political community is self-sufficiency. Here, self-sufficiency must not be understood in the first place to be economic self-sufficiency, but rather it is social and political self-sufficiency. After the state becomes self-sufficient legal political order, economic sufficiency will eventually occur if its families and individuals will move from their individual confinement to form association to satisfy their needs and economic wants through mutual help and sharing. How self-sufficiency is related to political life. St. Thomas Aquinas, in his Treatise on Kingship, also known as the Recno, explained that the chief concern of the ruler of political community is to secure the unity of peace, because the community's welfare and prosperity lies in the preserving unity and peace in the city. If there's no peace, the benefit of social life is lost, and the community is in a disagreement becomes burdened with self. But Aquinas concerned more than creating maintaining peace in the city for the sake of welfare and prosperity. Most importantly, human beings need to be guided toward a designated path that is proper to human beings, for Aquinas is union with God. So the purpose of political government is to help its citizens to achieve this end. The Recno illustrates the constitution of the city cannot achieve the ultimate purpose with city alone, but also upon the skill and qualities of the ruler who can guide the citizen toward their proper end as human being. St. Aquinas assumes that the ultimate end of human being is the union with God. He explained that it pertains to the king to promote the good life of the multitude in such way to make it suitable for the attainment of heavenly happiness. So the ultimate end of political community is the beatitude, the heavenly happiness. So the pursuit of happiness must be guided and directed by a skillful and good qualities ruler. The pursuit of happiness has indeed become the central purpose of constitutionalisms, but their diverging conception of happiness. For the proponents of positive constitutionalisms, they equate happiness with welfare and prosperity. For Roman Catholic constitutional theory, the political community is the community that aims to achieve the highest human good, its self-sufficiency in human life. While welfare and prosperity are important, they are not the ultimate end. The earthly ruler should promote the welfare of the community and fittingly toward happiness of heaven. As Jesus said, one does not live by bread alone. So now I'll move to the next part, the distinction between Roman Catholic constitutional theory and political theology. Again, the term political theology is conceived in different ways by different thinkers, but I will limit myself now on Carl Smith political theology. In 1922, Carl Smith published his treatise on political theology. Smith's overall argument is not the state and constitution are derived from faith based on regulation. Rather, he simply wants to show that there is something like God in the theory of state. His argument is that there must be someone or concrete body that has authority to insert, that is the sovereign. Like the figure of Christ on earth, the Pope is disposed to be sovereign of the pontifical state. So he argued that there must be a sovereign that can protect individual citizens from the chaos that result from the lack of consensus are of the monastic worldview. There must be a sovereign who holds the authority to decide who is the enemy and who are the friends. By reviewing Smith's works, we can assume that he does not rely on any revealed religion or even religion at all. What matters the most for him is the idea of the sovereign. Roman Catholic constitutional theory is based on a radically different approach than Smith's theory. Roman Catholic constitutional theory is not concerned with who embodies the authority to decide. The most important aspect is reason and will of the one that makes the decision. A decision that is based on reason brings political order, and a decision that motivated by an ordered will lead to the political community to the highest good. So the fundamental virtue Roman Catholic constitutional theory is the virtue of prudence, which presupposes the ordering of our disordered affections by the moral virtues, preventing us from losing sight of the virtuous ends. When Vice President J.D. Vance mentioned the principle of ordo amoris, both sides missed the point. Because basically it is a counsel of prudence. It is not an absolute moral maxim. Accordingly, the debate on ordo amoris is vitiated by the fact that each side in our politics presumes bad faith in the other side, which is in itself a violation of command to love our neighbor. The virtue of prudence is closely related to righteousness, as the Book of Wisdom says, if one loves righteousness, whose books are virtue, she teaches moderation and prudence. St. Thomas says it belongs to the law to direct human acts according to the order of righteousness. So now we can see the Trinitarian theology behind Roman Catholic constitutional theory. God reveals himself as one God in the all law, withdrawing human beings from idolatrous relationships and instructing them to worship the one God. The all law contains the revelations of the moral precepts. Nevertheless, the all law shows that simple human beings cannot perfectly follow a God-given law. Only Christ can help to fulfill the divine law through the new law. Under the new law, people continue to obey the moral precept of the all law, but celebrate the fulfillment of the precept in sacrifice of Christ. Christ fulfills the administration of justice by undergoing suffering for all sins. And after Christ, the Holy Spirit alone can move human beings toward the beatitudes of eschatological participation in the eternal law. Finally, I must discuss briefly the distinction between a theocratic constitution and the Roman Catholic constitutional theory. So what is theocratic constitution? Take, for example, the Irish Constitution, which explicitly states in the preamble, in the name of Most Holy Trinity and our obligations to our Lord, divine Lord Jesus Christ. So there is guarantee explicitly here. The Irish Constitution does not necessarily mean it is based on Roman Catholic constitutional theory. Some of the architects and the drafters of the Constitution might have some Catholic political thought in their mind when they drafted the Constitution. But in its current form, the Irish Constitution may no longer be based on Roman Catholic constitutional theory, especially after the series of constitutional amendments that include same-sex marriage and abortion in the body of the Constitution itself. Roman Catholic constitutional theory, however, is different from theocratic model constitutions. Roman Catholic constitutional theory does not advocate an inclusion of the canon law or Mosaic law in the written text of the Constitution. Roman Catholic constitutional theory does not seek to produce a single model or written text of a constitution. There are many ways that Roman Catholic constitutional theory would influence the life of a nation, and many aspects of Roman Catholic constitutional theory can manifest without adopting a specific constitutional text that mention in the name of Holy Trinity or Jesus Christ. Nevertheless, Roman Catholic constitutional theory is based on the Trinitarian God, which created capable of self-communication through reasons and dialogue based on coercion instead of coercion and punishment. Joseph Ratzinger explained that the term dialogue can be derived from two words, dia and logos. It implies that the logos as both reason and word. The God made flesh to be communicated, to be understood precisely as a reason. Consequently, Roman Catholic constitutional theory will act in accordance with logos, instead contrary to God's nature. So my principal claim is that Roman Catholic constitutional theory does not require a single text of constitution or religious corrective clause, but it is based on a Trinitarian doctrine. Roman Catholic constitutional theory, which is based on Trinitarian doctrine, places human and natural law in context of salvation. For human law informed by natural law is concerned primarily with temporal goods. It also opens to the divine law and eternal good. Human law and natural law can only attain the good they aim for through the saving work of Jesus Christ and the guidance of the Holy Spirit. As I said in the beginning of this lecture, Tocqueville proposes a new political science in his Democracy in America, but he never defined clearly. Some scholars have come up with a different interpretation of a new political science. While no one has come up with a definitive explanation of the meaning of new political science, I believe it was Joseph Ratzinger who has the correct intuition to insinuate that Tocqueville's new political science is a seed of Roman Catholic constitutional theory. Tocqueville himself never articulated that there is a Roman Catholic constitutional theory, but at the heart of Tocqueville's constitutional project is the common concern for redemption of humanity in the democratic era. In other words, Tocqueville's new political science is a redemptive constitutional project that aims to redeem humanity. Similarly, Roman Catholic constitutional theories aims to immaterialize modern people by detaching themselves from exclusive desire for material longings. In other words, such Roman Catholic constitutional theory aims to redress a moral imbalance that always favored material needs under the pretext of positive constitutionalisms or common good constitutionalisms. Like Tocqueville, who believes that human souls must be the center of attention of political scientists, Roman Catholic constitutional theory is concerned with degradation of the souls of the politicians and citizens. But more importantly, the central concern of Roman Catholic constitutional theory is the fallen state of human soul after original sin. Therefore, it aims to create a new constitutional order that could contribute to healing of the wounded soul. Finally, at its core, Roman Catholic constitutional theory is based on logos. Philosophical truths become personal, divine truth in Jesus Christ as the logos. Roman Catholic constitutional theory acknowledges that the perfection of liberty must not come through the law and coercion, but rather by reaching the interior movement of the souls and forbidding coercion. And Christ alone as the logos who can reach the interior movements of the soul and make the ultimate meaning of constitutional liberty possible. Thank you.
Thank you very much. And in many ways, such a timely placed lecture for all of us.